class, Article 13 refers to mitigating circumstances. So there are 12 mitigating circumstances which are reflected in your on the screen, class. So we have incomplete, justification, and exemption. Okay, so mo ni siya ang katotoang mga justifying circumstances and exempting circumstances nga incomplete, kato akong na-mention ganina nga incomplete ang iyang mga elements. So for example, sa self-defense, so what if sa URL or unlawful aggression, reasonable means employed to repel it, anya L, lack of sufficient provocation on the part of the person defending himself. So nay usa ana sa R o sa L ang nawala nga element. So mahimo siyang instead nga instead nga mahimo siyang justifying circumstances tungod kay incomplete man ang iyang mga elements, mahimo na lang siyang mitigating circumstance under paragraph 1 article 13. Okay, but remember class ha nga sa ato ang incomplete justifying circumstances dili jud pwede nga ang unlawful aggression may wawagtang. Kay kung mawagtang gali ang unlawful aggression, dili siya mahimo nga mitigating circumstance. So ma-zero na siya, dili na magamit. Okay? So under 18 or over 70 years old ang ato ang offender, no intention to commit so grave a wrong. So remember your praeter intentionem, mo ni siya class, paragraph 3. Sufficient provocation or threat, immediate vindication of a grave offense, passion or offuscation, voluntary surrender, voluntary plea of guilt, plea to a lower offense, physical defect, illness, and analogous circumstances. So what is the concept of mitigating circumstances? Mitigating circumstances do not entirely free the actor from criminal liability but serve only to reduce the penalty. So unsa man day ang basis nga naman nga i-decrease man ang penalty because they are based on the diminution of either freedom of action, intelligence, or intent on the or the lesser perversity of the offender. So mo nang maynusan nato ang penalty. So there are circumstances under Article 13, generally, ordinary mitigating circumstances, those mentioned under Article 13. However, your paragraph 1 class is treated as a privileged mitigating circumstance. So, ang privileged mitigating circumstance class o ordinary mitigating circumstance are two different animals, okay? Sa ordinary mitigating circumstance, mo decrease lang na siya sa period. So minimum, maximum, imbes nga mahimo siya maximum, pwedeng ma-medium siya or pwedeng ma-minimum kung daghan ang present nga ordinary mitigating circumstances. However, ang effect class sa privilege mitigating circumstance kay ang degree maoy maminusan. So unsa may pasabot og degree class? Based sa inyong na-learn sa inyong Article 25. Unsa man to inyong na-learn sa Article 25 class? Ang degree class mo na siya ang katutoa bitawng degree mismo sa kanini ang pagkasunod sa krimen. So for example, from presyon correctional to presyon mayor, mo na siya ang degree class. Pero ang katutoang mga periods for divisible penalties, katong na ay minimum, maximum o minimum, medium, and maximum, mao na siya ang maapektuhan sa ordinary mitigating circumstance. Okay, so ang privilege mitigating, ang Article 13 class generally speaks of ordinary mitigating circumstance. Pero ang paragraph 1 is considered as privileged mitigating circumstance, meaning makaminus siya og 1 degree. Okay? So you have to relate Article 13 with your Article 63 and 64. So it is meaningless to know Article 13 without knowing Article 63 and 64. So you have to connect, class, ha. It is your obligation to connect these kind of provisions sa revised penal code. Kaya again, the magic of connection. So dili siya pwede nga imo siyang tan-awon sunod-sunod lang. Dapat you know how to connect and where to connect it. So what is your Article 63? So your Article 63, class, is mentions about the rules for the application of indivisible penalty. So unsa man yung mga indivisible penalty, class? Ang indivisible penalty na to is reclusion perpetua. Meaning, wala siya minimum, walay medium, walay maximum. So, kung single indivisible penalty gali siya, class, it shall be applied by the court regardless of any mitigating and aggravating circumstances. You have to remember this, kay mo gawas yun siya sa atong exam. Okay? In all cases in which the law prescribes a penalty composed of two indivisible penalties, the following rules shall be observed in the application thereof. So, napabay duha ka indivisible penalty sa ato ang revised penal code. So, wala naman tay death penalty karon, class. So, ang nag-inusara na lang nato nga afflictive and indivisible penalty is reclusion perpetua. So, you have to check your Article 25. Class, you need to check your Article 25. Unsa man ang giingon sa inyuhang Article 25? Let's go to Article 25, class, ha. So, your Article 25, class, talks about katong mga penalties which may be imposed. So, naatay capital punishment which is death. Wala na siya karon, di ba? Kay kanang kuan naman ang application, gi-suspend man ni. I-abolish ang kana imposition of death penalty. Afflictive penalties natay reclusion perpetua, reclusion temporal, unyan sa correctional penalties natay prison correctional, arresto mayor, suspension, destierro. So mao ni siya ang ato ang gi-tan-aw sa i-relate sad sa ato ang Article 13. So ang kanini ang sa inyong may bawan later on, class, kaning ato ang penalties, class, important ni siya nga you have to master the penalties, how to compute, because certainly ma-relate man gani ninyo, class, sa other articles sa revised penal code. So for example, your Article 63, it is important to connect this, your Article 63 and 64, it is important to connect this to your Article 13 because naghisgot manggod ta og pag-decrease sa penalty. So malamang dapat kay bawta kung unsa ang penalties, unsa ang degrees, unsa ning mga periods. Okay? So again, your Article 63 talks about single indivisible penalty. So regardless of any mitigating and aggravating circumstance, wala kay i-minus because wala na siya minimum, medium, maximum. So it will be applied regardless of the presence of mitigating or aggravating circumstances. So you have to read your kanini ang Article 63. So, Article 64 talks about the application of penalties which contain 3 periods. So, katong akong gi-mention ganina nga minimum, medium, maximum. So, in cases in which a penalty prescribed by law contains 3 periods, whether it be a single divisible penalty or composed of 3 different penalties, each one of which forms a period, in accordance with your Articles 76 and 77, the court shall observe for the application of the penalty the following rules, according to whether there are or are no mitigating or aggravating circumstances. So kung walay aggravating o walay mitigating circumstances, class, they shall be imposed in its medium. Okay? According to your Article 64, ha? Pero kung may only one mitigating circumstance present in the commission of the act, they shall be imposed, the penalty shall be imposed in its minimum. only a mitigating ha, pero wala po siya aggravating. Walay silbing usara ba ang ni-attend. So, ang third nga rule is kung only an aggravating circumstance is present in the commission of the act, pero wala siya kada mitigating, aggravating ra ang naa. So, you have to impose the penalty in its maximum. Pero class, when both mitigating and aggravating circumstances are present, the court shall reasonably offset. Unsa may pasabot og offset? Meaning, imong i-minus, marabag ika ng ibangga nimo ang aggravating o mitigating. So, ibutang na to mas daghan ang present nga aggravating. So, ibutang na to tulo ka aggravating unya ang mitigating usara ka buok. So, malamang ang iimpusar sa korte ana is dako-dako jud nga penalty. Ngano man kay pag offset nilang duha, mas gamay man ang mitigating. Okay? So, you have to remember class, sa offsetting sa penalties class, ang ordinary mitigating circumstance class o ordinary aggravating circumstances mao lang na siya mo offset. Okay? Dili ka pwede maka-offset sa privilege mitigating circumstance imong ibangga sa ordinary aggravating circumstance. Okay? So, dapat pariha. Ordinary, para ma-offset sila. So, fifth rule, when there are two or more mitigating circumstances and no aggravating circumstances are present, the court shall impose the penalty next lower to that prescribed by law in the period that it may deem applicable. So, this time class, kung two or more mitigating circumstances, walay aggravating, mao na nga mo apply na ka next lower sa degree prescribed by law. Okay? So, next lower to that prescribed by law. So, butang na to, ang gi-prescribe kintahay sa balaod is reclusion perpetua. So, unsa may next lower sa reclusion perpetua? Reclusion temporal. In the period that it may deem applicable. So, sa discretion sa court, kung unsang applicable nga period. Minimum ba, medium, or maximum. Okay? Sa sixth rule, whatever may be the number and nature of aggravating circumstances, the court shall not impose a greater penalty than that prescribed by law in its maximum period. Okay, so for example, ang penalty sa krimen kay presyon koreksyonal. Okay? Presyon koreksyonal gali ang penalty sa krimen class in its medium period. Mao kintay na siya ang penalty sa krimen as prescribed by law. So, bisan pag 15 kabuok aggravating circumstances ang present attendance sa pag-commit sa krimen, dili jud na mo lapas og presyon koreksyonal maximum ang iimposar sa korte. Dili na siya pwede nga moambak nga from presyon koreksyonal mahimo siyang presyon mayor or reclusion temporal tungod kay 15 kabuok aggravating circumstances. Kung unsa ang gi-impose sa balaod, mao ra jud na siya. Maximum ra ang pinakalimit ana nga i-apply sa korte bisan pag unsa kadaghan or nature sa aggravating circumstances present. Ngano man class, it is related to your article. Unsa man ang pinaka-importante nga provision sa balaod ani sa revised penal code? You relate this to your article 21. Unsa man ang giingon sa article 21 of the revised penal code? No felony shall be punishable by any penalty not prescribed by law prior to its commission. Okay? So, ang penalty nga gi-impose din sa balaod, maura dyan na siya, imong i-apply. So, kung daghan kayo og aggravating circumstances, dili ka pwede nga magbuot-buot nga moagbak ka sa higher degree. Maximum ra jud ka kutob. Okay? So, nasabtan class ha. Okay, so let's compare your ordinary mitigating circumstance and privileged mitigating circumstances. So again, as mentioned a while ago, ordinary mitigating circumstances can be offset by any aggravating circumstances. Privilege mitigating cannot be offset by aggravating circumstances. Ordinary mitigating circumstance, if not offset by aggravating circumstance, produces the effect of applying the penalty provided by law for the crime in its minimum period. Meaning, kung siya ra ang present kato kung dimension nga rule ganina, siya ang present ra mitigating circumstance ra walay ning offset nga aggravating, mo tong i-apply nimo siya sa minimum period. In case of divisible penalties, again, kani mga divisible penalties, mao ni siya ang katong mga penalties nga gi-prescribe sa balaod nga naay minimum, medium, and maximum period. Okay, privilege mitigating circumstance. In contrast, the effect of imposing upon the offender the penalty lower by 1 or 2 degrees than that provided by law for the crime. So again, ordinary mitigating circumstance, naghisgotay resulta sa period. Period klasa minimum, medium, maximum. Privilege mitigating circumstance, mas dako siyang impact class. Nga naman, degrees ang ato ang gihisgutan. Okay? So, Article 13 talks about the enumerates the mitigating circumstances. So, number 1, those mentioned in the preceding chapters. O sa mga preceding chapters, justifying circumstances and exempting circumstances. When all the requisites necessary to justify the act or to exempt from criminal liability in respective cases are not attended, meaning dili kompleto ang elements. Number 2, the offender is under 18 years of age or over 70 years. In case of the minor, he shall be proceeded against in accordance with Article 80. The offender, third, had no intention to commit so grave a wrong as that committed. Praeter intentionem. That sufficient provocation or threat on the part of the offended party immediately preceded the act. Okay? Fifth, that the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, descendants, legitimate natural or adopted brothers or sisters, or relatives by affinity within the same degrees. So ato na ning na hisgutan po ning mga relatives ninyo class no nga si sadback, spouse, ascendants, brothers or sisters og affinity and katong consanguinity. Pero this time class wala siya consanguinity ha, sadba ra ni siya. Okay? Affinity raning hisgutan na to kutob sa paragraph 5. So sa 6th class, that having acted upon an impulse so powerful so as naturally to have produced passion or obfuscation. So masabtan ni nato later. So on and so forth. So dili na lang nako ni basahon class ha. Kamo lang siguro ang mobasa ani kay aron nga dili na kana aron kamo ba independently, you have to read this because it's your obligation. So it's my part to kuanhimay and to explain the details na siguro. So let's go to your paragraph 1, incomplete justifying or exempting circumstances. So the circumstances of justification or exemption which may give place to mitigation because not all the requisites necessary to justify the act or to exempt from criminal liability are attended. So, mo ni siya ang following cases. So, sa self-defense, defense of relatives, defense of strangers, state of necessity, mo ni siya. Kaning 1 to 6, mo ni siya ang mga covered sa Article 11. Kaning 7 to 9, mo ni siya ang covered sa Article 12, katong mga exempting circumstances. So, let's go to incomplete justifying circumstances. So, ang katong incomplete self-defense, defense of relatives. So, kung ano siya ha? Self-defense, defense of relatives, o defense of strangers. So, kanus aman siya matawag na tong incomplete nga justifying circumstances of self-defense, defense of relatives, and strangers. So, mo ni siya class ang explanation. In these 3 classes of defense, unlawful aggression must always be present. Ako na dyan yung gimension ganina. So, kung walay unlawful aggression, ayaw mo paghisgot nga magamit nimo siya as mitigating circumstance. Okay? So, you have to remember nga you have to relate this to your Article 69. Unsa man di ay ang giingon sa imong Article 69, the magic of connection. So your Article 69 class talks about privileged mitigating circumstance which lowers the penalty by 1 or 2 degrees. Unsa man ang giingon sa Article 69? Penalty to be imposed when the crime committed is not wholly excusable. A penalty lower by 1 or 2 degrees than that prescribed by law shall be imposed if the deed is not wholly excusable by reason of the lack of some of the conditions required to justify or to exempt from criminal liability in the several cases mentioned in Articles 11 and 12, provided mo ni siya ang requirement class that the majority of such conditions be present, meaning majority sa mga elements must be present. So ang akong gi-mention ganina class, di ba niingon si kung incomplete justifying circumstances, dapat ang unlawful aggression consistent siya, constant siya. So at least sa R o sa L ra ka pwede nga mawagtangan ana nga mao nga element, pero dili pwede nga si R o si L mawala. Ngano man kay si Article 69 class nag-require nga majority of the circumstances must be present. So at least usa lang jud or at most usa lang jud ang mawagtang niya nga element. It's either reasonable means employed to repel the unlawful aggression or katong lack of sufficient provocation. So on and so forth. Katong sa second and third elements sa defense sa stranger o sa defense sa relatives. Okay? So, incomplete justifying circumstances of avoidance of greater evil or injury. Under your paragraph 5, Article 11, mao ni siya mga requisites class. The accused acted in the performance of a duty in a lawful exercise of a right or office. And, number 2, that the injury caused or offense committed be the necessary consequence of the due performance of such duty or the lawful exercise of such right. So, according to the Supreme Court, sa People versus Owanes class, the Supreme Court considered one of the two requisites as constituting the majority. Ngano man, duhara man ni sila. So, ngano maghiskutay pamatag majority kung duhara. Pero, ingon si People versus Owanes nga, kung usa ang mawagtang ana, unya usa ray magpabilin, nag-constitute na siya as majority as required by your Article 69. Okay, so let's go to incomplete justifying circumstance of performance of duty. Okay, so performance of duty, you have to go back to the elements na lang class sa kanang justifying circumstance of performance of duty. Kung naiusa galian na nga mawagtang, meaning dili na siya justifying circumstance. Mausa naman siya, mahimo na siyang mitigating circumstance. Under paragraph 1, incomplete justifying circumstances, or paragraph 1, article 13, or incomplete exempting circumstances. Okay? So, what are the incomplete exempting circumstances? Number 1, incomplete exempting circumstance of accident. Under your paragraph 4, article 12, the person is performing a lawful act, mano siya ang mga requisites, with due care, and he causes an injury to another by mere accident, without fault or intention of causing it. So, it is my humble opinion, class, nga under your article 4, Article 12, Paragraph 4, there is no such mitigating circumstance. Ngano man, wala tayo gitawag og incomplete exempting circumstance ani, nga mahimo siya mitigating sa accident. Ngano man, class, if the second requisite manggod and the first part of the fourth requisite, kana nga itong mga gipang underlinean og red, kung ang second requisite nga with due care ang mawagtang, unya ang first part sa paragraph 4 kanang without fault ang mawagtang, mahog manggod siyang reckless imprudence, class, under article 365. Walay due care, meaning reckless imprudence siya or negligent siya. Unya without fault, meaning culpa siya. Okay? So, kung mawagtang mangguna sila, class, ma-convert manggod siya into reckless imprudence. So, wala tayo gihisgutan nga mitigating siya. Unya, kung ang first requisite sad nga kaning gibluhan nato, person performing a lawful act, meaning ang iyang gi-perform dili lawful, nahimo na siyang unlawful. Kung mahimo na siyang unlawful class, unya ang second part sa fourth requirement nga nahimo siyang intentional na siya intention of causing it, kay kanang di ba ang requirement sa paragraph 4 dapat without intention of causing it. So this time kung may mawagtang siya, mahimo na po siyang intentional nga gibuhat nimo. Unya ang requirement number 1, imbes nga lawful act siya, na unlawful act na siya. So unsa may mahitabo, ma-convert po siya into intentional felony. So kaning accident class, it is my humble opinion nga if you analyze it kanang kuan bitaw thoroughly, wala jud siya gitawag og incomplete exempting circumstance of accident. So there is no mitigating circumstance under this paragraph. Okay? So, incomplete exempting circumstance of uncontrollable fear. So, under your Article 12, mo ni ang mga requisites nga there is threat which caused the fear. The threat which caused the fear was an evil greater than or at least equal to that which he was required to commit. That it promised an evil of such gravity and imminence that an ordinary person would have succumbed to it. So if only one of these requisites is present, there is only a mitigating circumstance. Okay, let's go to under 18, paragraph 2, or over 70 years old. So in lowering the penalty based on age of the offender at the time of the commission of the offense, not the age when the sentence is imposed. So always remember this one, class. At that time, kung unsa ang iyang edad at the time of the commission of the offense. So in lowering the penalty, as in using it as mitigating circumstance. Pero kung maghisgot tay galit nga ang iyang age is at the time the sentence is to be promulgated, meaning dili sa time sa commission sa offense class, dili na ta maggamit ana, dili na mahimo nga mitigating circumstance class. Unsa ra man atong ma-impact ana niya, masuspend lang, in suspension of the sentence under your Article 80. So again, class, para matawag siya mitigating circumstance, ang age nga imong gihisgutan nga under 18 ug over 70 years old must be present at the time of the commission of the offense. So let's go to the legal effects of various ages of the offenders. So kung 15 below, class, ato na ning gihisgutan sa minor, sa exempting circumstances. 15 and below, exempting siya, absolute. Above 15 years old and 1 day but below 18 years of age, also exempting, pero unless he acted with discernment. Diba? Exempting lang siya if the perpetrator or the CICL did not act with discernment. Pero kung ni-act siya with discernment, he will be proceeded against by law. Mapadayon ang iyang kaso. Okay? So, kung ang minor delinquent is under 18 years of age, the sentence may be suspended. So, kung 18 years or over siya, full criminal responsibility na. 70 years or over, mitigating siya. No imposition of death penalty if already imposed. Execution of death penalty is suspended and commuted. Okay, so unsa may basis nga naman nga katong under 18 ug over 70 years old na may mitigating circumstance i-decrease man because na diminution of intelligence. So let's go to paragraph 3. No intention to commit so grave a wrong. Diminution of intent gihapon ang kanini ang basis ani. So unsa man ning praeter intentionem, class? The requirement is that there must be notable disproportion, meaning dako jud kaayo ang disparity, ang gintang between the means employed by the offender and the resulting harm. For example, ang offender iya ra untang gikusi. Unya ang effect sa iyang pagkusi ning likay ang katutuang nga kuan, ning likay ang iyang nga gikusi, paglikay padapang ka ang iyang ulo, namatay. Okay? Unsa man ang iyang means nga gigamit, pagkusi. Unsa man ang effect nga harm nga nabuhat, namatay. So mo na siya ang gitawag og notable disproportion, meaning dako kayo ang gintang sa means employed by the offender and the resulting harm. Okay? The intention as an internal act is judged by the following: proportion of the means employed, ang katong fact nga ang blow or ang katong iyang aim or iyang injury is a vital part sa body, the weapon used, the injury inflicted, and the attitude of the mind. Okay? So, ana ni mo mahibaw-an kung naa ba dyo'y intention. So, makaklaim ba siya aning wala dyo ko intention to commit so grave a wrong for it to be mitigating circumstance. Okay? So, the lack of intent to commit so grave a wrong is not appreciated where the offense committed is characterized by treachery. Unsa man dining treachery, you will learn later sa inyong aggravating circumstance nga kaning treachery class, kaning ang offender bitaw ang accused kay does not afford the kanang victim bitaw of means sa defense to defend himself, kana bang surprise attack ba. So kung mag-surprise attack ka, ayaw jud og pagpabuang-buang og ingon oy nga no intent to commit so grave a wrong. Wala ko intention to commit so grave a wrong. Mo nang dapat i-mitigate ang ako nga kanini ang liability. No, because lack of intent to commit so grave a wrong cannot be appreciated kung naa kay treacherous act, kung treachery na kay gigamit nga treachery in the commission of the offense. Okay? So you have to remember class again. Ako na dyan yung gibalik-balik kung mention ninyo nga kaning praeter intentionem class cannot be used sa kadtong anti-hazing law. Ngano man class, ang anti-hazing law specifically provides nga dili jud na pwede nga gamiton as mitigating, maklaim as mitigating circumstance ang praeter intentionem or no intention to commit so grave a wrong. Ngano man kay pwede siyang abusuhon. Nga kana bitaw maghazing-hazing, moingon ra kintay ka nga o kung wala pa nagibutang sa balao dinha nga naay praeter intentionem, ang praeter intentionem dili pwede mahimo mitigating circumstance, pwede na abusuhon sa katong mga inyohang mga kauban sa fraternity nga kanang ilang pagbunal-bunal, moingon silang ay namatay man siya pero wala biya ko intention to commit so grave a wrong. Ako ra biya yung intention no kay mo bunal ra to welcome the person sa amo ang brotherhood. So dili na siya pwede sa anti-hazing law. So dili ka pwede nga makagamit ni ana. Okay? So let's go to sufficient provocation or threat. What are the elements? The provocation must be sufficient, that it must originate from the offended party, that the provocation must be immediate to the act, to the commission of the crime by the person who is provoked. So, unsa may pasabot ani provocation? Kani mga improper conduct, unjust, or act of the offended party capable of exciting or inciting or irritating anyone. So, ang provocation class, lahi ni siya sa unlawful aggression. Ang unlawful aggression class, physical violence jud siya, directed to the person defending, claiming self-defense. Ang provocation class, minor ra ni siya nga, gamay ka na maka-irritar lang ba? Dili necessarily kaning physical violence. So, capable of exciting or inciting or irritating anyone, mo na siya ang provocation. So, kung ang katong biktima maoy nag-perform sa provocation class, mo na siya nga maklaim nimo siya as mitigating. So, provocation, in order to be mitigating, must be sufficient and immediate preceding the act. So, kung ang krimen, dapat ang commission sa crime, ang imuha nga provocation sa offended party kato imong biktima must immediately precede or module na siya ang gi-perform before sa commission sa crime, meaning immediate siya. Okay? Unsa may pasabot og sufficient? Sufficient means adequate to excite a person. Okay? So kanang magbuli-buli lang ka, mayan ka nga, oy kaning kuan kanang baho man ka og kaning kuan, oy baho man ka og ilok, baho man ka singot. Nya kana na kay normal na ninyo nga mga friends. So you cannot consider that normal ninyo ba nga inyong sige buli-buli every day. So you cannot consider that as sufficient provocation. Sufficient provocation is kanang not normally done, dili normal ninyo nga inyo nang gipang binuang unya imo nang ma-mention or imuhan nang mabuhat nga imong mabuhat sa imuhang kauban unya makuan nimo siya kanang maka-excite niya, makapalagot niya, mao na siya ang sufficient provocation. Sufficiency of the provocation depends upon the following: the act constituting provocation, the social standing sa person provoked, and the place and time when the provocation was made. So kung ikaw kintahay kanang nag-provoke ka in private, so dili na siya matawag nga sufficient provocation nganong wala man gupo siya ma-humiliate so much so nga makakos nga malagot siya kay kamo ra man pong duha. So ang sufficiency sa provocation class will be assessed on the following kanang items. Okay? So let's go to kuan class. Let's go to immediate vindication of a grave offense. Okay, so what are the elements? That there be grave offense done to the one committing the felony, his spouse, ascendants, descendants, legitimate brothers or sisters, or relatives by affinity. Okay, sad ba ragyapon ni siya, wala ni siya consanguinity ha. So the felony is committed in vindication of such grave offense. A lapse of time is allowed between the vindication and the doing of the grave offense. The vindication need not be done by the person upon whom the grave offense was committed. So, okay, let's take note nga ang lapse of time is allowed. Meaning, pwede ra nga, dili siya pareho sa kuan class ba? Dili siya pareho sa provocation nga immediate jud siya. Dapat, immediate jud ang immediately ning precede or kanang nag-una ang provocation sa krimen nga nakomit nimo. Okay? So, dire sa kaning immediate vindication of a grave offense, ang vindication class, pwede nga from the time nga nakomit ang grave offense, pwede nga na-lapse of time para mo vindicate ka. Para ang imong vindication or ang imong pagpanimaos ba will be considered mitigating circumstance. Unlike sa kaning sufficient provocation, ang requirement sa balaod is sufficient and immediate siya. So meaning, ang iyang provocation dapat nagsunod jud siya immediately, naguna jud siya immediately sa imong pag-commit sa offense. Continuing siya ba? Pero diri sa kanini ang immediate vindication of a grave offense, meaning ang grave offense nga na-commit against nimo or sa imuhang sa sadba sa katong imong spouse, imong ascendants, descendants, or imong brothers or sisters, or katong relatives by affinity, ang katong nga grave offense na-commit dili necessarily immediately after ana nga mo vindicate ka. So pwede nga na-lapse of time. So kung ning vindicate ka despite the lapse of time, considered gihapon siya as mitigating circumstance. Nga naman kay ang Spanish text manggod ani is proxima ang gitawag, proxima meaning proximate, dili siya necessarily immediate. Okay? So, the question whether or not a certain personal offense is grave must be decided by the court having in mind, again, balik yapon ta, social standing sa person, sa place, and time when the insult was made. So, vindication of a grave offense and passion or obfuscation cannot be counted separately and independently, ha. Kaning vindication of kanang kuan manggod class of grave offense, mao-mao ra po ni siya sa fashion or obfuscation. So kung mahitabo gali na siya kanang kung mao-mao ra siya nga circumstance ba, mao-mao siya nga kaning kuan, mao-mao siya nga attendant facts. So kung usa gali ra na siya ka krimen unya mao-mao ra siya nga circumstances, usa ray pwede nga maklaim nimo. It's either vindication of a grave offense or passion or obfuscation. Dili pwede nga magamit ni nimong duha. Okay? So, In People versus Torpio class, the Supreme Court said nga, the mitigating circumstance of sufficient provocation cannot be considered apart from the circumstance of vindication of a grave offense. These two circumstances arose from one and the same incident, the attack on the appellant by the accused, so that they should be considered as only one mitigating circumstance. So, ako na nang na-mention ganina. Okay? So, as mentioned earlier gihapon, akong gi-compare ang provocation o vindication. Sa provocation, under your paragraph 4, o ang vindication sa paragraph 5, gi-compare na to ha. Sa provocation class, the provocation is made directly only to the person committing the felony. Okay? Sa person nga ning claim sa mitigating circumstance. Ikaw nga ning claim sa mitigating circumstance, dapat ikaw directly ang giprovoke. Ang vindication class, ang grave offense may be committed against the offender's relatives, katong si sadba. Okay? Katong spouse, ascendants, descendants, brothers or legitimate, natural or adopted brothers or sisters, or katong relatives by affinity in the same degree. So, kung naay grave offense nga gi-commit atong mga tawhana nila ni sadba, pwede nga imong magamit ang kaning vindication of a grave offense as a mitigating circumstance. Pero kung made directly gali siya nimo, pwede ka mo gamit sa provocation. Okay, next distinction. The offense need not be a grave offense. Sa provocation. Ang provocation kay di ba kanang akong gi-mention kanina, anything nga maka-irritate or maka-incite, maka-excite sa kaning person, unjust or kaning dili maayo nga improper nga conduct sa person. Mao na siya provocation. Pero ang vindication class, the law is specific nga the offended party must have done, katotoang party ba, katong biktima, must have done a grave offense to the offender or his relatives. Grave offense jud dapat ang iyang gibuhat. Okay? Next distinction, the provocation or threat must immediately precede the act or the commission of the crime. So meaning, ikaw nga gi-provoke, mo jud dapat nag-una immediately before ka naka-commit sa krimen. Okay? Vindication class, the grave offense may be proximate, which admits an interval of time. So, pwede ra siya nga, after na-commit ang grave offense against imuhang sadba, katong spouse, etc., pwede nga na interval of time between the grave offense done by the offended party and the commission of the crime by the accused. So, another thing, provocation, it is mere spite against the one giving the provocation or threat. Meaning, kalagot. Spite is kalagot. Pero, ang kanini ang vindication class, it concerns the honor of the person. Okay? So, what is the basis class? Why it is considered mitigating? Ano maka-decrease man siya sa penalty ang kaning vindication or pagpanimaus, imong gi-vindicate ang honor sa imuhang sadba. Unsa man siya ang basis? Diminution of the conditions of voluntariness. Okay? So, let's go to your paragraph 6. Your paragraph 6 class is passion or offuscation. Okay? So, what are the requisites? The accused acted upon an impulse. Impulse, meaning automatic siya class. The impulse must be so powerful that it naturally produces passion or offuscation in him. That there be an act both unlawful and sufficient, unlawful, sufficient to produce such condition of mind. And fourth, the said act which produced the offuscation was not far removed from the commission of the crime by considerable length of time, during which the perpetrator might cover his normal equanimity. So, unsa may pasabot class? So, kung ato siyang sunuron class in layman's term, dapat na-adjoy unlawful act, sufficient siya, both sufficient and unlawful, nga gibuhat sa katong biktima. Siya ang nag-una, nay unlawful act. Tungod sa unlawful act, nay impulse ang kanini ang automatic ning react ang kanini ang ato nga person, the accused, claiming the mitigating circumstance. Okay? So kaning impulse is so powerful nga kanang nakaproduce siya og passion or obfuscation, meaning ang katong act ng God nga gibuhat nakaproduce siya, nakatrigger siya og impulse dito sa akusado nga nakatrigger jud sa iyang passion or obfuscation, kanang nalagot jud siya, apektado jud siya kaayo, class ba, and that the said act nga kanang which produced the kanang obfuscation, katong unlawful act nga gibuhat sa maong biktima is not far removed. Unsa may pasabot og not far removed, meaning dili siya, walay taas nga interval of time within which si perpetrator or kani si akusado nga naka-recover na siya sa iyang normal equanimity. Unsa may pasabot og normal equanimity, kana naulian na siya, class ba, sa iyahang kalagot. So dapat ang iyahang ang kanidyong unlawful act sa katong biktima, sufficient and unlawful act, dili should siya dapat layo sa katong pag-react pod sa mao nga akusado. Okay? So, passion or obfuscation must arise from lawful sentiments. So, unsa may mga examples ani, class? Unsa may mga example? Kani, the mitigating circumstance of obfuscation arising from jealousy. Okay? So, for you to be able to claim ba, class ba, passion or obfuscation as mitigating circumstance, class, dapat lawful ang sentiments nimo, meaning na akay katungod nga mo feel that way. Okay? So you have to remember nga ang passion or obfuscation, class, not applicable siya when the act committed is in the spirit of lawlessness or committed in the spirit of revenge. So for example, kaning jealousy, class, dili ka pwedeng maka-claim, class. Kaning jealousy, it is an impulse. Legitimate siya nga impulse, class, nga imong normal nga ma-feel kung makakita ka sa imong hinigugma nga tuan na dito naglulambijog na siya dito sa lain nga laki. Okay? So normal na siya nga reaction sa human being, pero as far as the law is concerned, class, and for you to be able to claim a mitigating circumstance of passion and obfuscation, class, it must come from lawful sentiments. Usa may pasabot ani, kaning jealousy, class, dili na nimo maklaim kung illegitimate pod ang inyong relasyon. For example, ang imuhang relasyon, class, ani ni ang imuhang kanang sa kabit kintahay nimo. Unya nagselos ka ka imong kabit dito nagbiga-biga dito sa lain nga laki. So dili ka pwede maka-claim aning passion or obfuscation, class. Ngano man dili man god legitimate, dili man legal sentiment ang source sa imuha nga impulse or sa imuha nga jealousy. Okay? So, passion and obfuscation, class, may lawfully arise from causes existing only in the honest belief of the offender. Okay? So, bisan pa, class, og dili jud tinuod nga naa siya gikasilusan, ang passion or obfuscation, dili ba tinuod ba nga naigibuhat ang katong iyahang for example, ang iyaha kintahay nga katong uyab kintahay or iyahang wife is naglulambijog na dito sa lain nga laki. Unya katudeng lakiha nga isang gikalulambijog kay izahara day pong igagaw. So bisan pa og ang gibati nga jealousy sa bana ba is ning arise siya bisan pag dili tinuod ang katong iyahang gihuna-huna nga kabit to sa iyahang wife, mag-claim gihapon niya ang passion or obfuscation. Ngano man, class, it may arise lawfully arise from causes existing only in the honest belief. So, honest belief niya nga honest belief sa offender or sa husband nga naigibuhat nga daw taniyang wives, despite the fact or regardless of whether or not tinuod to ang gibuhat sa wife. Okay? So, Let's go to kuan class. Kanini ang nga kaso. In US versus De La Cruz kas dugay na ni siya kaayo nga kaso, pero it is a classic example of passion and obfuscation. So De La Cruz, in the heat of passion, killed the deceased who was his querida upon discovering her in the act of carnal communication. Sa maning carnal communication, nahibaw na mo unsa na siya class, kana mao na siya with a mutual, mao na siya kana inyong giunahuna kamo mga ngilad og mga hunahuna, mao na siya with a mutual acquaintance. He claims that he is entitled to the mitigating circumstance kuno of passion or obfuscation, and that the doctrine in Hicks is inapplicable. Okay, so in this case class, niingon si Supreme Court, the impulse upon which the defendant acted was the sudden revelation that his paramour was untrue to him, and his discovery of her in flagrante in the arms of another. This was sufficient impulse in the ordinary and natural course of things to produce the passion and obfuscation, which the law declares to be one of the mitigating circumstances. Okay, so mo ni siya ang while kirida ni siya class, di ba nag-mention mo ko ganina ninyo nga kanang in my humble opinion katong lawful sentiments, meaning dapat ikaw nga kanini ang ning claim ana na ang mitigating circumstances of passion or obfuscation, dapat lawful sentiments ang gigikanan ana, meaning dapat ikaw mismo dili pod lawful pad ang imuhang relasyon anang imuhang gikasilusan. Pero class, in this case class, si Supreme Court gi-recognize siya kirida man niya, gi-recognize siya nga nakaproduce gihapon og passion or obfuscation kay iya hamang nakit-an in flagrante or caught in the act in the arms of another. Okay? So let's go to voluntary surrender, paragraph 7. Voluntary surrender and confession of guilt. So there are two mitigating circumstances under paragraph 7, voluntary surrender and voluntary confession of guilt. So you have to remember class, the kanini ang requisites ani. So voluntary surrender ang requisites that the offender had not been actually arrested. Okay? So wala jud siya actually ma-arrest. Pero bisan pag na-issue ang warrant, in this case class, whether or not a warrant of arrest had been issued is immaterial and irrelevant. Ang inyuha nga basihan kung actually na-arrest ba siya. So, kung wala pa siya actually na-arrest, regardless kung standing na ng warrant din ha, pwede ra gihapon siya maka-voluntary surrender. Number 2, that the offender surrendered himself to a person in authority or the latter's agent, that the surrender was voluntary. So, the criterion is whether or not the offender had gone into hiding and the law enforcers do not know of his whereabouts. So, ang man po mo tawag na to siya voluntary surrender kung ang akusado o ang mga kapulisan nakahibawag asa na siya unya kung ano na siya unsay ganini ang arestuho na siya, di ba? So for voluntary surrender to be appreciated, the surrender must be spontaneous, made in such a manner that it shows the interest of the accused to surrender unconditionally to the authorities, either because he acknowledges his guilt or he wishes to save them the trouble and expenses that would be necessarily incurred in his search and capture. Okay? So, let's go to kanini ang mga important doctrines diri class. The accused must actually surrender to the person to his own person to the authorities. Okay? Next, nga important inyong hinunduman, merely requesting a policeman to accompany the accused to the police headquarters is not voluntary surrender. Kanang magpauban lang ka niya, wala jud kay intent kay imong angkunon ang complicity or imong involvement sa crime, that is not voluntary surrender class. Okay? What is the effect of arrest? So, ang arrest man good class, as a general rule, it is not mitigating when defendant was in fact arrested. So, kung arrested na ang maong akusado class, ngano maghisgot pa magkag mitigating circumstance of voluntary surrender? Nga ning kuan nagali siya, kanang arestado na gali siya. So, unsa man ang mga exceptions ani class, ma-consider gihapon siya nga voluntary surrender class bisan pag arestado na siya kung after committing the offense, the accused voluntarily waited for the agents of the authorities and voluntarily gave up. Okay? So, who are these persons in authority and his agent? Kinsa man ni sila? Define ni siya under Article 152 class. Again, the magic of connection. Article 152, you have to connect this provision. Unsa man ang person in authority? Person in authority class is one directly vested with jurisdiction. That is a public officer who has the power to govern and execute the laws, whether as an individual or as a member of some court or government corporation. So, sa may mga example ani, barangay captain, barangay chairman, considered na siya nga persons in authority. Mayor, governor, kay nga no, na siya jurisdiction, unya, na siya power to govern, mo ni siya mga magic terms, power to govern and execute laws, mo ni siya ang persons in authority. Agent, kinsa man ni si persons in authority class gitawag nako siya PIA, PIA. Pero si APIA or APIA, agent of person in authority, mo ni sila ang mga persons who are charged with the maintenance of public order and the protection of security of life and property and any person who comes to the aid of persons in authority. So by provision of law or by election or by competent authority, gihatagan ni silang obligasyon to maintain public order, peace and public order, protection sa life and security sa property. So kinsa man ni mga examples ani? Kamo, mga pulis. APIA mo class, dili mo PIA. APIA mo, agent of persons in authority. Okay? So, let's go to plea of guilt or katong voluntary kanang kuan. Ang second circumstance aning paragraph 7, voluntary confession of guilt. Unsa may tawag ana niya? Plea of guilt. Okay? So, unsa man ang requirement sa plea of guilt? That the offender spontaneously confessed his guilt. Number 2, that the confession of guilt was made in open court. Dapat in court siya klasa. Dili pwede nga sa police station or dili pwede nga unsay nga nini ang kaning social media kintay siya, mag FB live siya adto siya mo confess sa iyang guilt or magpakuan siya sa kanang magpa-press conference siya adto siya mo angkon sa iyang guilt. No, dapat in open court siya. And dapat made before the competent court that is to try the case. Okay? So, again, tungod aning requirement number 2, extrajudicial confession. Unsa may pasabot og extrajudicial? Out of court, extrajudicial. So, dapat kanini ang plea of guilt, dapat judicial confession siya, made in open court. Pero kung extrajudicial confession or out of court, made by the accused, it is not voluntary confession of guilt. Therefore, it is not considered as mitigating circumstance. So, third element, the confession of guilt was made prior to the presentation of evidence for the prosecution. Meaning, dapat before pa nakapresentar o ebidensya si prosecution, mo confess na ka sa imong guilt. After nagali ka mo confess, after the presentation of evidence, it is not anymore a mitigating circumstance class. Okay? So, unsa man ang importante nga inyong timan-an po dire? Dapat ang inyong confession of guilt class is certain jud mo and decided mo nga ning confess jud mo sa guilt. Conditional plea of guilty class is not mitigating. Okay? So, a plea of guilt on appeal is not mitigating. Ngano man, on appeal nagali siya class, human na class. Human na og present ang evidence sa prosecution. Kanang appeal class meaning na human na ang inyuhang nga kaso sa lower court mo nang imo na siyang gi-raise sa higher court. So, therefore, nahuman na ang presentation sa evidence. So, plea of guilt on appeal na dili na siya mitigating. So, withdrawal of plea of not guilty before presentation of evidence by prosecution is still mitigating. So for example, before kintahay sa stage sa during arraignment class, mahibaw-an ninyo sa inyong kaning criminal procedure during arraignment kintahay, niingon kintahay si akusado nga not guilty. Mo na iyang giingon na dili ko guilty sa unsa man ang imong plea ani ni kana Mr. so and so, kana the accused. Niingon siya not guilty. O not guilty siya. Pero later on, pero before pa ning present og evidence ang akusado, nausab iyang hunahuna, iyang gi-withdraw ang iyang not guilty nga plea. Unya ning angkon na pud siya sa iyang nga kanini ang krimen, ning plea na siya og guilty. So this time, pwede siya nga mamihimo nga mitigating class. Nga naman, nahimo man siya or na-perform man na niya before the presentation of the evidence by the prosecution. So wala mag-require ang balaod class nga dapat ang imuha ra jud plea is guilty jud ka. Pwede ka nga nag-una nga not guilty ka sa una, pero sa time nga wala pa ma-present ang evidence sa prosecution, ning change ka, naguna-huna ka nga ay magmuangko na nandiyo ko sa akong salaoy, ning plea ka o guilty, it is still considered a mitigating circumstance. Okay? So what is the basis? Lesser perversity of the offender. Nganong lesser perversity, ngano kanang kasi pasabot og perversity class sa Bisaya pa, lesser ka animal ba? Lesser ka kriminal. Okay? So, ngano man nga gitawag man nato siya lesser perversity tungod kay ning voluntary surrender gud ka, ning voluntary angkon gud ka sa imong sala. So meaning dili ka tantong daotan. Okay? So let's go to the next paragraph. Paragraph 8, physical defect. So you have to remember class nga ang physical defect class must be connected to the crime committed. Okay? So, the physical defect that a person may have must have a relation to the commission of the crime. So, for example, class, where the offender is deaf and dumb, meaning kanang kuan siya, kaning bongol, personal property was entrusted to him and he misappropriated the same. So, ang crime nga na-commit ani is estafa. The fact that he was deaf and dumb is not mitigating. Ano man? Because it does not bear any relation to the crime committed. Ang imong pagpangilad class, sa imong pagpangilad class, wala makaapekto nimo ang imuhang kabungol. Kung mangingilad jud ka, bisan pagbungol ka or kanang amang ka, wala na makapa kaning kuan ba unsay nga nini ang makapa decrease bitaw class or naka-affect ba sa commission sa imong offense, meaning dili kaayo ka for example kanini ang class B kay naglisod ko explain sa inyo ha. For example kintahay physical injuries. Unsa man ang related kaayo sa kaning physical injuries nga crime nga physical defect pod sa perpetrator or sa accused. For example, kuan siya, kanini ang buta siya. Ang iyang pagka-blind class nakaapekto sa iyang pag-perform sa krimen nga physical injuries. Therefore, kanang blindness niya pwede siya nga magamit as mitigating circumstance. Okay? Another example, if a person is deaf and dumb and he has been slandered, he cannot talk, so that what he did was he got a piece of wood and struck the fellow on the head. The crime committed was physical injuries. The Supreme Court held that being deaf and dumb is mitigating. This time mitigating siya because the only way is to use his force because he cannot strike back in any other way. Okay. So, unsa man ang kuan class? Unsa man ang gi-require day sa palaod ani class? Ang sa requirements sa balaod class, ang physical defect referred to in this paragraph is such as being harmless, crippled, or a stutterer, whereby his means to act or to defend himself or to communicate with his fellow beings are limited. So, mao ni siya ang pinaka-important nga requirement sa physical defect class kaning naa sa B. Okay? Dapat ang iyahang nga physical defect maka-limit niya sa iyahang means to act, sa iyahang means to defend himself, or means to communicate sa others para mahimo siyang mitigating circumstance. So, in this second example, gislander siya. Sa may pasabot o gislander, gipagkauwawan siya ba in front of other people. So, tungod kay deaf siya or dumb siya, meaning, dili siya kakuan, kanang deaf siya, dili siya maka dungog. So, while gipakauwawan siya sa atubangan sa mga tao, dili man siya makadungog class. So, ang means niya to defend himself or to kanang retaliate, limited kaayo. So, tungod ani, in this case, tungod kay limited siya, dili man ko makaistorya, unya maglisod mo kog dungog nimo, ako na lang kang bunalan og binugha. So, ang iyang krimen nga na-commit class, iya na lang bunalan ang katong person nga napakauwaw niya. So this time, the Supreme Court recognized nga yes, ang iyang pagka-deaf and dumb ani nga kaso is kaning kuan na ay relation to the commission of the crime. Nga naman, makonsider jud siya nga mitigating circumstance because the Supreme Court said the only way the Supreme Court held that that being a deaf and dumb is mitigating because the only way is to use his force kato iyang pagbunal because he cannot strike back in any other way. Lisod man siya. Okay? So, ang means to defend himself is limited. Mao na nga makonsider nimo ang physical defect as mitigating circumstance. So, number 9, illness. What are the elements sa illness? That the illness of the offender must diminish the exercise of his willpower. Number 2, that such illness should not deprive the offender of the consciousness of his acts. Kaya kung gideprive siya class sa consciousness sa iyang act, insanity na siya class. So kung insanity, unsa naman siya? Mitigating siya or exempting? Exempting siya. So mao nang ang requirement sa illness class, dapat ning diminish lang sa iyang exercise, sa iyang willpower. Pero kung completely na-deprive na gali siya sa iyang consciousness or sa iyang willpower class, mahimo na siyang exempting circumstance. Ngano, matawag naman siyang insanity. Okay? So, these are the important rules that you have to remember sa illness. When the offender completely lost the exercise of willpower, it may be an exempting circumstance. O, sige, mention na nako ganina. It is said that this paragraph refers only to diseases of pathological state that trouble the conscience or will. Okay? A mother who under the influence of puerperal fever killed her child the day following her delivery. Okay ba nun sa puerperal fever, meaning nagdelirium. Okay? So, diminution of intelligence and intent ang basis sa illness. Okay? Ang inyo ra dyan timanan ni class because I might ask you during the exam para mahimo siya mitigating nga circumstance nga illness class ning diminish lang siya sa iyang willpower. Kung completely nawag tanggali ang iyang consciousness, dili na siya mitigating circumstance of illness class ha, unsa naman siya? Exempting circumstance of insanity or imbecility. Okay, let's go to let's go to paragraph 10, analogous mitigating circumstances. Unsa man ning analogous? So similarly situated circumstances as those mentioned nga kato mga nag-una from 1 to 9, similarly situated, maumao ra ba siya class ba? Meaning, sa mitigating circumstances class, I might ask you during the exam, mitigating circumstances class, dili siya exclusive nga enumeration. Meaning, dili lang siya from 1 to 10. Meaning, there are analogous circumstances, mitigating circumstances. Meaning, there are circumstances not mentioned from 1 to 9, wala ma-mention from 1 to 9, however, similar siya sa katong mga nag-una nga gi-mention nato from 1 to 9. So, mo ni siya ang paragraph 10. So, any other circumstances of similar nature and analogous to the 9 mitigating circumstances enumerated may be mitigating. Okay. So, unsa man unsa may mga example sa the act of the offender of leading the law enforcers to the place where he buried the instrument of the crime. Kanang ang offender kay iyahang gitudluan ng mga police officers nga diri ba na gitaguan ang ako ang mga hinagiban paggamit sa pagpatay aning biktima is tantamount or equivalent to voluntary surrender. Number 2, stealing by a person who is driven to do so out of extreme poverty is considered as analogous to incomplete state of necessity. So, katong paragraph 1 na to, di ba, ang state of necessity class is a justifying circumstance. Pero, kung incomplete ang iyang elements, mahimo siyang mitigating circumstance under paragraph 1. Kaning state of necessity class, pwede siyang matawag na to nga analogous circumstance. Ang kanana ang analogous circumstance of incomplete state of necessity kung kanang nangawat ka tungod kay gigutom na jud ka. So mao na siya, pwede siya nga himo nga analogous mitigating circumstance. Kaning over 60 years old with failing sight is similar to over 70 years of age mentioned in paragraph 2. So voluntary restitution of stolen goods is similar also to voluntary surrender. Usa rin voluntary restitution kanang imong giuli ba, imong giilisan ang katong imong mga gikawat. Okay, it is tantamount or similar to voluntary surrender. Impulsive jealous feelings is similar to passion and obfuscation. Okay, extreme poverty and necessity similar to incomplete justification based on state of necessity. Ako na nang mention. Just testifying for the prosecution without previous discharge is analogous of plea of guilty. Kani magong mahimo kang state witness class, dapat gi-discharge jud ka, meaning nakay gihuwat ba nga nakay gihuwat nga kanibang kanang premyo ba, kani magong mahimo kang state witness class under your rules of court. You will learn that sa imuhang kaning criminal procedure o sa inyong evidence, ma-mention po ni later nga kung mahimo kang state witness class, part ana sa imong pagka-state witness is ang imong prize pa, imong premyo nga makuan ka kanang ma-dismiss ang kaso against nimo. Okay? Pero this time, kung ning testify ka for the prosecution, meaning ning testify ka ning ikaw mismong akusado ning testify ka in support sa pagpasaka o kaso sa imuha for the prosecution, bisan pa og wala ka gi-discharge, wala kay premyo nga i-discharge or i-dismiss imong kaso, it is analogous to plea of guilty, which is a mitigating circumstance. Okay, class. So, I hope you learned sa inyong 10 kanang mitigating circumstances which have the effect of decreasing the penalty. So, again, you have to remember your Article 13 refers to, generally speaking, are ordinary mitigating circumstances. Ang effect niya is reduce siya sa period, minimum, medium, or kana maximum. Mo na siyang i-reduce niya. Pero there is an exception nga gitawag nato siya privilege mitigating circumstance, which is your paragraph 1. Unsa man ang effect niya, dili lang period ang iyang i-decrease. Ang iyang i-decrease is degrees na jud siya, class. Okay? So, mas dako ang impact sa privilege mitigating circumstance. And you have to relate that to your Article 69. So, I hope you learned from our discussion. I will upload this later. Please take note of important points because I will be giving additional points to notebooks reflecting the notes ani nga mao nga recording. Thank you!